Welcome to the Prevent the Preventable podcast, where we're on a mission to change the landscape of brain hemorrhages by driving awareness, delivering education, and pushing for real action. Now, brain hemorrhages affect millions of lives every single year. But at the Nathy Kate Moss Trust, we're committed to preventing them before they happen and funding pioneering research to advance treatment for when they do. In this podcast, we'll dive deeper into the world of brain hemorrhages because the more we understand, the more we can create real change, and together we can truly prevent the preventable. Hello and welcome to today's episode of the Prevent the Preventable podcast. And I'm really excited about today's episode actually, because it's going to bring a lot of really helpful practical advice to people whose lives have been affected by a brain hemorrhage. Today, we're going to be speaking to the sponsors of our podcast, Hugh James Solicitors, and discussing with them the legal complexities that can follow a brain hemorrhage, from navigating wills and probate after a sudden loss, to seeking specialist legal advice if there are concerns about potential medical negligence or delayed diagnosis. It goes without saying that brain hemorrhages are so incredibly confusing. Everything happens so quickly. There are words you don't understand. 1 minute, everything seems okay and under control. Then the next, it doesn't. You start asking, did something get missed? Did they have the right treatment? Could more have been done? Then what happens if the individual has sadly passed away and didn't have a will? What happens when everything goes through probate? More unnecessary stress. Not only have I experienced this personally, at NKMT we regularly receive emails from individuals asking for advice. But these are complex concerns and need experts to answer them. Today, I am so pleased that we'll be joined by solicitors Leanne Jones and Jill Edwards from Hugh James, a top 100 UK law firm and also sponsors of our podcast. Leanne, a senior associate at Hugh James, specialises exclusively in wills, trusts and probate. She has significant experience advising a broad range of clients on the preparation of wills and estate planning, and her work often involves navigating sensitive family dynamics and complex personal circumstances. Jill initially trained as a nurse at Manchester Royal and requalified as a solicitor in 1997. Since then, she's represented claimants in a wide variety of clinical negligence claims, particularly those who suffered brain injury due to stroke, hemorrhage or birth injury, and those who suffered spinal injuries or amputations. Today, we're going to look at the legal process for families seeking accountability, as well as what happens legally when someone dies without a will, and therefore how to prepare and update a will proactively. Now, before we go into today's episode, if you haven't already listened to the first episode of this second series or the episodes in series 1, I highly recommend you go back and have a listen. There is so much helpful information in there, from how to prevent a brain hemorrhage, what research is being done at the University of Manchester to better treat them when they do happen, and more real life stories about how others have navigated this dreadful experience. But today's compassionate, informative conversation is essential listening for anyone affected by the legal aftermath of sudden neurological events, and for those who want to be better prepared. So, without further ado, let's jump in. Ladies, welcome to the Prevent the Preventable podcast. Thank you so much for being here. Now, obviously today, as I've already said in the introduction, we're going to be talking about the legal complexities that can follow a brain hemorrhage. And let's be honest, probably a number of other things in life, but obviously we're going to be focusing on brain hemorrhages. I've introduced you both, Leanne and Jill, but probably in your own words, can you share a little bit more about who you are and what you do? So Leanne first.
So I'm Leanne. I'm a senior associate solicitor at Hugh James. I've worked there for about 16 years now. I specialise in wills and probate, lasting powers of attorney. That's been a real focus of mine throughout my whole career, and it's a real passion of mine, and you never cease to be amazed by the different people that you meet in this field.
Yeah, I'm sure it's in ever, there's sorts of new stories, new experiences,
Absolutely.
New things that you come across all the time.
Yeah.
It's always a challenge, I'm sure. So we'll probably come on to that especially. So, and Jill, what about you?
Hello, I'm Jill Edwards and I'm a partner at Hugh James in the Clinical Negligence Department in Manchester. I've specialised in clinical negligence all of my career since 1997, and particularly I want to give people a voice when something's gone wrong, and we have an excellent team there. We all work very closely together And I think it's important to raise standards in medical care through the work that we do, as well as helping individual families. So combined, I think that's been a real focus of mine to try and achieve that.
Yeah, and I think that's a really good point straight away, is that, and I've spoken to a number of solicitors in your firm about this, is that actually you think about medical negligence lawyer, they're wanting to, get money, let's say, from something that's gone wrong. And that's actually not the point. The very point that Hugh James solicitors in themselves are supporting this podcast is because they want change.
Mm-hmm.
They want these things to not happen in the first place, but they're there to hold people accountable for when
exactly.
they do, which I think is a good point.
Absolutely, and give people answers, because very often that's what's lacking. When something's gone wrong, everybody wants to know how it's happened, and the case can sometimes give the answers.
Yeah, absolutely. So let's start with medical negligence then. So obviously, as I said before, we want to focus on brain hemorrhages. Now, brain hemorrhages are obviously devastating. They're instantaneous. They just happen. In the last episode of this first of series 2, we were speaking to Stuart Allen, and we talked about, how brain hemorrhages are very different to a lot of other things. You don't have a diagnosis period. You don't have, time to figure things out. Maybe it's all happening so quickly. There's lots of questions. There's quite a lot of confusion for families. There's words that you don't understand. You think for 1 minute that everything's fine, and then suddenly it's not. And you do ask, they're doing the right thing. Did something get missed? And then it starts leading you to a question of was there medical negligence? Could this have been prevented? And so we'll talk all about that. But I think what I'd love to just start with is understanding in itself, what is medical negligence?
Well, whenever I speak to somebody who might have a claim, what I'll explain is that the first thing to remember is that there are a number of things that need to be proved to succeed in a case. And so we're looking at the standard of care, and the person in question is judged against somebody in the same specialism. So if it's, for example, a GP who hasn't treated high blood pressure, or it's a problem in the emergency department and it's an emergency physician or a nurse, it will be somebody in that same field who will be judged. So as a lawyer, I'm not deciding whether that person was negligent. We're obtaining an independent expert opinion on that. But that's not the end of the story, because even if we can prove substandard care, we also have to prove what's called causation. And simply put, that means on the balance of probabilities, the outcome would have been different if that care had been appropriate. And that's often the difficulty, because everybody who comes to hospital or to see a doctor has something wrong with them. And so we're having to decide, with the help of experts again, what path that would have taken had they had the right treatment compared with how things are now. And it's only if you can establish both of those things, that the injury would have been avoided, or that the negligence materially contributed to that injury, that you then are able to process that and proceed with the allegations. And if you can succeed in it, then claims the compensation. But it's based upon being judged by their peers. And often I think people are worried about pursuing a case because they feel as though the NHS are doing the best they can. And of course, nobody goes to work thinking they're going to be slapdash that day. But it's a very high hurdle to prove negligence. And it's only those cases where they have been judged to be substandard by their peers that will succeed. So I think any guilt involved in that decision, people don't need to feel that way. Sometimes the care doesn't follow the path that ought to have been taken. Sometimes that's a systemic failing or a lack of communication, but it will only succeed if somebody judges that is substandard.
Yeah, and I'm sure it's incredibly complicated. There's so many factors involved, whether that is, the situation, there's a number of things that could be going on in that situation. There could be different people available. There's so many things to consider as well, which must make it very complicated. One as a case, but probably also for the family. And, if they're considering medical negligence in the first place, I suppose a question might be for somebody is what signs might I look for if I think medical negligence might have happened? What would you suggest to people to be thinking about if that's something they're considering?
Well, I think there are two aspects to that. One is somebody may have suffered a brain hemorrhage, possibly because they have untreated high blood pressure. So perhaps if they have been back and forth to the GP and that hasn't been treated properly. That's perhaps one aspect, because I know your own researchers and experts involved with the charity have very clearly pointed out that consistently high blood pressure can damage the vessels and make you more susceptible to a brain hemorrhage. The more usual scenario, however, that we see in cases is where somebody has sought help for a really quite severe headache, often referred to perhaps as a thunderclap headache, a very sudden severe headache or a worsening headache, and they've been sent home rather than investigated. So a classic example of that would be where a particular case I'm thinking of where somebody went back and forth to the GP with a severe enough headache to go and seek medical attention, which is often, I mean, for a lot of men particularly, that's, to take that step alone is quite telling, isn't it? But when it became really severe, they went to the emergency department and they were seen by the triage nurse, and the nurse then deflected them to what's called an acute admissions part at the emergency department, where they were seen by a nurse practitioner. So they were never actually seen by a doctor. And unfortunately, and this was admitted by the trust, the people who saw him didn't appreciate the significance of his symptoms, which included vomiting by then, and discharged him. And sadly, 2 or 3 days later, he collapsed at home, came back in, and he'd had a subarachnoid hemorrhage. And at that point, the hemorrhage was so severe that he'd suffered a very serious brain injury and needed 24-hour care. And the case was all about, and the defendant again admitted this, had he had a series of investigations which should include a CT scan, which would, on the balance of probabilities, have diagnosed the hemorrhage, and that would have been an early bleed. The earlier, 2 or 3 days earlier, it would have been a smaller bleed, and it would have led to something called a CT angiogram, which would then have diagnosed an aneurysm, so weakening in one of the vessels, and he would have been able to have had fairly straightforward treatment, which would have involved coiling the aneurysm, which would have blocked it off effectively. And so the second catastrophic bleed 2 or 3 days later would have been prevented, and all of those injuries would have been avoided. So devastating for him and the family, but also, putting it bluntly, very expensive for the NHS. And so, again, going back to the guilt that some people feel about pursuing these things, actually, people need to learn lessons from that, and it would have avoided all of those costs of looking after that poor man. And also, people need the right rehabilitation, equipment, therapy, and support from carers, because people have very complex needs after a hemorrhage. So that's an example of that sort of.
And I think, you listen to examples of that, and it makes me feel, emotional. I don't know about you, Leon, but I listen to it and I think, poor man, poor family, poor friends, the knock-on effect of that decision is huge. And obviously, this is your job, and there are many other people who work in medical negligence in Hugh James. There are many other solicitors that have medical negligence. So obviously this is reasonably common, but how often do you work on sort of hemorrhagic stroke medical negligence claims?
We do work on cases involving brain injury. The hemorrhagic stroke cases, thankfully, are not particularly common. Sometimes there isn't anything that anybody could have done to have changed the path of events, but families do want answers, because inevitably everybody wants to know why and how this has happened and could it have been prevented. But we will be able to tell people at the earliest possible stage whether there is any scope for pursuing a case, whether there's a reasonable prospect of success. To give you an example of a case that we would investigate and have done recently where it didn't actually proceed, but we obtained expert evidence. In that particular case, the initial warning headache had happened over a week before the eventual large hemorrhage, and the evidence from the neuroradiology expert, who would be the person on the ground, and in fact this expert does practice in this, would perform the coiling, said that probably it wasn't actually an earlier bleed, it was probably just the vessels spasming. And so even if the staff in the emergency department had done the CT scan or the lumbar puncture, there wouldn't have been any evidence of a bleed, which would have led to the angiogram to diagnose the aneurysm. So that chain of events couldn't be proved. And so we informed the family of that, and they were glad to have had the answers. In some ways, it's a comfort to families to find that out, that things couldn't have been any different. And obviously we're happy to do that if there's a reasonable prospect of some success in the case. We have to be honest with families. But because of the way cases are funded, it's a conditional fee agreement. A no-win, no-fee agreement. They won't have to pay for any of that. So it's our decision at the beginning with the family whether to proceed. And obviously the family doesn't need to worry about that once that decision's been made.
Yeah, and it's a long and drawn out process, isn't it? And I think there's a lot of emotional turmoil that happens throughout that long process. And I think, we'll talk about that in a moment, actually. But I'm interested on with the point that you were mentioning before around if there has been medical negligence that has been found, and you talk about the importance of actually that initiating change. What sort of change would there be if, in that first example that you gave, who then goes to initiate changes at the entire NHS? Because I know it's not that straightforward. You can't just initiate change in the NHS like that. Like, what does that actually look like?
Well, often if something has gone wrong, the staff will initiate an internal investigation. So if they are aware that something could have been done differently, they will begin what's called a datix form, which is a document that we can ask for if we start to investigate the case, which might say that there's been an untoward outcome, and that can sometimes trigger an internal investigation, and the trust themselves will obtain their own independent report, or at least look into it, and that can then lead to policy change within the trust. So what you might find, again, these are documents that we obtain in cases, is that perhaps predating that case, there might have been a policy for scanning people in a certain scenario, and then after that incident they might tweak that policy slightly to say we need to be more cautious and let's do it in this scenario. So there are national guidelines and obviously general medical training, clearly, but there are also local policy guidelines that can be influenced by that. And so by triggering an investigation, either internally or by us flagging up something that's gone wrong, it can positively lead to change in that way.
Yeah, great. And that's like what we said at the beginning. That's what you want, isn't it? I mean, obviously you don't want it to happen in the first place.
No, exactly.
But what you want is positive change.
I think that's some real motivation for a lot of families that come to see us, is we really don't want this to happen to anybody else. And that's a real driver.
Yeah, I think, you and I don't know whether you still do. I don't really watch terrestrial TV anymore. But you used to see these adverts of, have you tripped or fallen? And, you can make a claim. And the sense that you get with, maybe it comes from that, is that when you hear about medical negligence claims, you think that people are going, okay, well, I can maybe make some money out of this in some way. That's not the truth. And, and I think I've seen it personally. You start to think about, well, actually, no, in truth, you just don't want this to happen to other people. That's the basis of the work, to be honest, that we do at the Natty Kate Moss Trust, is we're trying to shift the landscape of brain hemorrhage, because from what we've seen, not enough is done. So whether that is through the prevention campaigns and, the conversation about blood pressure that you've already touched on there, Jill, or whether it's around the research, it's about initiating change.
Yes.
But I think, for families who are considering, potentially there is a claim here, something wasn't right. We do want to make sure that is changed for other people in the future. Where do they start?
Well, they need to make sure they're going to a specialist solicitor. And one of the best ways to check that is if the firm is recommended in the legal directories. So there's Chambers and Partners is a very respected legal directory, and their research is based upon cases that are submitted, the success of cases, but also recommendations from barristers and experts and clients who've had a good experience. So unfortunately, I think there are a lot of high street firms, and I'm sure there are some very good solicitors amongst them, who have on their list of expertise a wide-ranging expertise from wills and probates that Leanne will come on to speak about, but they're also dabbling in medical negligence. And I think for a case as complicated as a brain hemorrhage, I would definitely recommend finding a specialist.
And on that note, if I may plug the NKMT, but not plug, but we've recognised that we have a number of people that email us. We spoke before this podcast started, about people getting in touch with us saying, I'm not sure if something's happened that shouldn't have happened or didn't happen that should have happened. Subsequently, my loved ones passed away or they've got brain injury, to example before. And so we work with, solicitors like yourselves to make sure that we can direct people to, good, reputable firms. So on our website, our services page, we really want to make sure people have that, that pathway to get to those people. And we offer free calls. And as you well know, because it's so important, because it's so complicated and it's so complex and it's so emotional. Again, we'll talk about that, that we want to make sure that access point is there as well. Obviously, those links are in our show notes. But so, we talk about going to a reputable solicitor. And then what? Like, how long does the process take?
Well, the process can take probably realistically 18 months to 2 years, depending on how many experts you need to get to the point of being able to say, this is going to go somewhere. I mean, it can be much sooner than that if the initial report isn't supportive. But the process, the reason I give that sort of quite a long time frame is to give people realistic expectations, because I don't think there's any point. And it's probably a red flag if somebody says they can whip something off quickly for you. You would start by obtaining, well, obviously speaking and meeting the family. Obviously, the evidence that the family and the injured person, if they're capable of giving it, can give is vital. So that's the factual side of what's happened. We obtain all of the medical records and the radiology because there may have been brain scans. And it's important that the family get to see those records, and that in itself can answer some queries. But that's important also because sometimes things are recorded differently, not necessarily suspiciously differently, but inevitably when people are busy, they might just sketch something down that's happened, and that's not really the detail of how it happened, particularly if it's about somebody going back and forth with symptoms. Those symptoms are vital for us when we're investigating the case. So that's a big part of it. The medical records should be disclosed to us within 30 days. But then they're sorted and paginated, so that can take a few weeks to be done, so that when we and the experts are referring to a particular entry, let's say it's a blood pressure measurement or a brain scan, you can say bundle B, 245 page. That's the basic sort of nuts and bolts, if you like, of the case. But once all of those records and the witness statements are taken, then you would instruct the experts, and that's an important part of why you need a specialist solicitor, because you need to go to the right specialism, clearly, but also the best experts. Because if the answer is this wasn't negligent, you need to be able to rely on that as much as you need to be able to rely on an expert who say it was, and they then help you fight the case. So that's an important. We obviously have an expert database, and any of the specialist solicitors do the same. And the expert, again, unfortunately, if they are very popular because they're good, not because they're partisan, we don't want partisan experts, we want neutral experts who know their onions, then they often have long waiting lists. So that's a reason why that time estimate is so long very often. But you might need 2 or 3 experts, let's say. And also, when the cases are complex, as in a brain injury, you very often need all of those pieces of the jigsaw. So you might have one report, but you need to know what the other expert is saying. So going back to that example, the case study, we had a report from an expert in emergency medicine and also an expert in neuroradiology, because we wanted to know what the emergency medicine expert recommends should have been done in the investigation stage, had that person been properly investigated. But the neuroradiologist needs to be able to say what they would have done had they received that patient sooner, and talk about whether there was a bleed or not. And those 2 bits of the jigsaw fitted together to say, sadly, that chain of events doesn't really work and we can't pursue the case. So then once the expert reports are received, if they are supportive and the allegations are clear enough, we are obliged to follow what's called a pre-action protocol. So before you enter into any court proceedings, we send the defendant a letter of claim with the allegations in based on the expert evidence, and they then provide a letter of response, either admitting things or denying things and saying why they're denied. And it's only after that that you would then embark on court proceedings if our experts remained supportive. So in the face of what the defendant is saying, if they deny something for a reason, you might then have a conference with a barrister and with our experts to explore that. And a barrister would then advise on the prospects of success and draft what are called particulars of claim, so the court document setting out the allegations. And then the court process can take some time if it's denied. But if anything is admitted, even if you're then exploring the extent of the injury and the person's losses, we can request what's called an interim payment of damages. So that can shorten the impact on a family. And that's another reason why I think anybody who has had a significant injury, be that somebody's died or they have a significant brain injury, the important thing for the family and that person is to access funds as soon as possible. So get to the end of the liability process. If it's admitted or proved, get an interim payment that can fund carers if the family is struggling. Nobody's going to force anybody to have external care, but if they need it, they can. The right equipment, wheelchairs, etc. The right housing if that's necessary, so single-storey accommodation that's adapted. All the different therapists that tend to run out in the NHS. You're given a sort of time frame and a slot and then essentially told that's all we can give you and it's not really going to make much difference, but actually you need to keep things at bay, you need to keep tighten muscles at bay, and those sorts of reasons you need physio. So the case can fund all of that if you've proved negligence. So although it might seem a long time and it could be another 12, 18 months after you've issued court proceedings, if they've denied things, we can try and shorten that where we can and the impact of that on a family. But that's a reason why it needs to be carefully thought through before you embark on it.
Yeah. And I think, exactly to that point, it is. I mean, even listening to it, it's so complicated, isn't it? There's so many points by which you're like, okay, we'll get to that point, and every time it's an emotional roller coaster.
It is, absolutely.
And, not even just then the practical side that you mentioned about, well, what if somebody has survived, but they're actually severely disabled? And then there's all these additional complexities in life and additional costs, to your point of carers and wheelchairs and adaptability, and changes to the home. And the list goes on and on and on. So to add on to that, pursuing a case and not knowing if that case will follow through, not knowing if that case will end successfully, it's one thing having to have your life completely turned upside down by yourself having a brain hemorrhage or a loved one having a brain hemorrhage. But then this on top of it is just a whole other weight and sort of devastating process that you have to go through.
I think the thing to say about that, though, is that once you've started the process, we can then do that exploring for you in a way. I mean, you can sort of, in a sense, mentally free yourself up from all of that angst and wondering why and whether things could have been different by almost handing it over to us. And we will then touch base with you, for want of a better phrase, at regular intervals. But besides that, you can move on or deal with what you're dealing with and let us carry the weight of that really for you. There is the need to investigate a claim within 3 years of the actual negligence or your date of knowledge that you might have suffered an injury because of negligence, or 3 years of the date of death. If somebody doesn't have mental capacity, there isn't a time frame, but obviously while all the information is still fresh in everybody's minds, the sooner the better in that sense. But just bear in mind a 3-year limitation period if somebody does have mental capacity or within the death. I know that I've focused on the people who've sadly suffered a brain injury and survived and the outcome of that. But as you've also mentioned, Fiona, there are people who sadly don't make it after a severe hemorrhage, and the family can pursue a case in that scenario. Particularly, they may want to do that if somebody was a breadwinner or contributed to the family financially or even practically. So a parent, for example, where we would bring the claim on behalf of that person's estate, but also on behalf of their dependents. So that might be a dependency on their income, but also the services that they were providing, for example, as a mother or in any other way. So that, again, you're probably reeling from that happening clearly, but it's still something to think about if you're concerned about providing for the family in the future.
Yeah, absolutely. And I think, again, you're talking about it there. You're talking about the complexities that come with you've lost somebody, and then you're having to go through a potential medical negligence claim. But then obviously, as we talk about there, Leanne, just touching on the work that you're doing, then there's the process of wills and probate. And even if I talked to you before about this before we started the episode, from my father had a will. He was very organized in that sense. And, it still was complicated going through probate, even if he did have a will. So can we kind of unpick that a little bit? Because that's a stress I don't think that people recognize, and I also think there's lots of things that we can talk about here. There's the complication that, quite often somebody gets older, or if they are ill and there's this diagnosis period, they will prepare a little bit more. But with brain hemorrhages, there's not that opportunity. You don't have that time. And there are cases of people that are in their 20s, 30s, 40s and don't have wills. I know people, my partner, unfortunately, I'm going to call him out. He doesn't have a will. So, I think it's really important for people to be aware of the complexities that can happen when something happens. So, Leanne, what exactly does happen when someone dies without a will? Let's start with that. Hi, I won't take up too much of your time, but if you're listening, it's probably because you care about making a difference. And the truth is, we couldn't do any of this without you. Whether you've run a race, come to one of our events, whether you donate regularly, or have made a gift to us in your will, thank you. You're helping to fund life-saving research into brain hemorrhage treatment. Now, just £33.91 pays for 1 hour of research at the University of Manchester. That's 1 hour closer to improving survival rates and reducing long-term disability for thousands of people. And here's the thing, every pound makes a difference. In fact, if everyone who interacted with Series 1 of the podcast, whether by listening to it or downloading an episode, watching a YouTube clip, or one of our reels on Instagram, if all of those people donated just £1, we could fund half a year of research. And if you'd like to help, the link to donate is in the show notes. And it goes without saying, thank you for helping us save lives from brain hemorrhage. Now back to the episode.
So if you pass away without a will, you're known as intestate. Essentially, you've passed away without a will, you've got nothing written down what should happen with your estate after you've gone. There are set rules in place known as the intestacy rules. Those are very rigid, in essence, a hierarchy of people to benefit. So usually, if you're married, it'll be spouse, potentially your children alongside them as well. If not, then parents, siblings, and trickling down through the family ranks, so to speak, that way. In that sense as well, I think, as you say, they are rigid. So, if you haven't taken the positive step of making a will, then that will define who exactly is going to benefit from your estate. And I think taking that step as well, I think that positive action is one thing that you can do in some ways to give yourself that peace of mind that none of us know what is around the corner. As you alluded to, you could have people in their 20s, 30s, 40s that haven't even considered making a will, where something like a brain hemorrhage, a nasty accident could happen, and all of a sudden something has turned, over in a I can't even get my words out now. So something has turned on the toss of a coin, in essence, in some instances, and what is happened is predestined, and it might not reflect what their circumstances are. I think it's important to say as well that the intestacy rules, as I said, they're strict, they're predefined, but they don't necessarily reflect modern family arrangements. There's more and more people who are, say, cohabiting, who have stepkids from previous, by partners or from previous relationships, and those types of relationships and arrangements aren't reflected then in the intestacy rules. So if you've got a cohabiting partner that you want to provide for, that's one hell of a reason to make a will. If you've got stepkids that you consider your own, again, and those rules as well don't allow you to deviate from the what was the norm. Shall we say? It's not the norm anymore necessarily, but at the time they were written, and unfortunately haven't necessarily been reformed, you're going to be, your estate will be stuck with them.
Thank you to our sponsors, Hugh James Solicitors, for supporting this second series of the Prevent the Preventable podcast. Now, sudden brain hemorrhage can turn your world upside down, but discovering it was caused by a medical mistake makes it even more devastating. While nothing can change what's happened, Hugh James's medical negligence team is here to support those who suffered brain injury or bereavement due to medical errors. And their support doesn't end there. The Hugh James Wills and Estate team is also on hand to help you plan for the future with clarity and care, because when the worst happens, the last thing you need is added complexity. To find out more about how they can support you and your loved ones, head to the services page on our website and book a free call with them to discuss your concerns. You can find the link to all of that in our show notes. It's such an interesting point. I hadn't even thought about that. Life is very different now, isn't it, than
absolutely
even 20 years ago, I'd say. Yeah. And I think, it's not that there weren't sort of different arrangements then, but that is a very good point, especially, a lot less people are getting married and they are just, living together. And, there are lots of people that do have stepkids, and families are complicated, let alone we won't touch on the complexities within family dynamics and relationships anyway, but obviously that adds a layer on it. And I'm sure if, then you've got rules that say everything's split evenly within children, there's endless complications that we could talk about.
Absolutely. And there's certainly as well other factors that you can cater for in a will that maybe aren't looked into in the intestacy rules as well. So for example, if you don't write a will, then if your kids are benefiting under the intestacy rules, they'll get it at 18. You might not think that 18 is a sensible age. Well, you may do, but you may not think 18 is a sensible age for your children to take. By writing a will, you can say a later age. You could appoint guardians for them as well. There's often misconceptions about what might happen if you don't have a will, that, I've got a common law spouse, which in law isn't, it's not a recognised term. It's somebody who's cohabiting with you, and as we said, they won't benefit under the intestacy rules. And then likewise as well, perhaps another common misconception the other way that clients often have about them is, well, if I don't make a will, it's all going to go straight to the government. That's another one on the flip side of it, which isn't quite right. So you've got to go through the whole family before you get to that point, so not be able to find any of them living. But if you think about going down that hierarchy, there might be people in there you don't want. You don't want to get it. Yeah. A long lost cousin, for example, because you haven't got anybody.
So I've been at a networking event recently where there is a guy there, and I'm not sure the title of his role, but his role is basically finding, children of people who's died to manage.
A genealogist.
Yes, exactly. Yeah. And he'll find this, child that somebody's had with an effect. He goes really into kind of the story of somebody's life, and it's very interesting, and I'm sure it, throws up a lot of politics within families and a lot of, complications that people don't need. They've already gone through something really devastating. And this is why I think it's so important, this conversation today, because it is just another complexity that if we can, prevent those additional complexities from managing it appropriately, be proactive, it would help so much. And I think one of the biggest things I think for people is that, they're not going to be here, a little bit like, it doesn't matter, I'm not going to be around, so people can sort it. What would you say to somebody if they had that challenge?
We do get a lot of people saying that, actually, where you maybe ask them a question that they haven't considered before now. You do sometimes go, I don't mind because I'm not going to be here. Tough, they'll sort it. There is that additional stress, as you say, that you're putting onto somebody, particularly if you've got a family that maybe don't always get along. Or maybe there is a child that's not been around for years, and probably realistically you wouldn't necessarily want them to benefit alongside the ones that have been there for you. But by not taking the step, you're kind of burying your head, and they are going to benefit equally. How are your close children going to feel about that? How's that dynamic going to go between the children? Is there going to be a bit of a row, or, are you putting extra stress in that sense on them, not just in the kind of the admin side of things, and the need to sort everything out from the estate perspective, but the kind of the emotional stress, I guess, obviously having lost a parent, and then perhaps dealing with the fallout of how the estate is now going, or having to maybe rekindle a bit of a relationship with a long lost sibling that maybe they'd prefer not to, for example.
Yeah, and I think it's that emotion. We've spoken about it already. We've spoken about it a few times, actually. It's the emotional side of it. You think of law and you probably think, maybe it's just me, but you do think it's quite systematic. It's process. It's what's written is rigid, or there is interpretation, sure, but you don't necessarily think of the emotional side of things. But there's so much emotion that comes with this, and I think that as much as you can lessen those emotions and help people, the better. What I'm really interested as well is about certain misconceptions that people have when they're making a will, or when should I make a will? Let's say someone's 30. Should they make a will then, or am I too young? I'm likely going to be fine. Do I even bother needing to go through that process? Huge thank you to Colony Co-working for continuing to support the Preventable podcast. Now, at the Nathalie Kate Moss Trust, we have huge ambitions to completely change the landscape of brain hemorrhages. And whilst we're a small but mighty team, we're all working remotely. And in truth, that's part of our strength. Remote working means that we can connect with incredible talent from across the UK and around the world, helping us push forward faster and smarter. But without a central office, we need flexible, inspiring spaces where we can come together to work productively, collaborate meaningfully, and work on this huge goal we have set ourselves. That's where Colony comes in. Colony is a growing network of beautifully designed co-working spaces here in Manchester, home to creatives, founders, freelancers, and teams of all sizes. They are spaces built for focus, connection, and progress, not just a place to work, but an environment that actively supports your growth. And they've helped NKMT do just that. To find out more about how Colony could support your business, check the link in the show notes.
You do get a lot of people, again, thinking along those lines, maybe, nothing's going to happen, I'm fine, this is an older person's issue. But obviously, as we said, things can turn on the throat of a dice. You never know what's around the corner. And I think equally, if you've got something to give, if you've got significant asset, a significant enough asset in, say, a house, even if, there's a mortgage on it, if you've got children, taking the step of using a will to appoint a guardian for them if you are, and maybe their other parent aren't about. And I think as well, they're one of those things that you can put in place. They're an insurance policy, they're there when they're needed, but they can be changed in future. So if you did one today that reflects today's circumstances, one, that's peace of mind. You've taken that proactive step. You've said your piece about where everything's going to go. You've lessened the load on the family, but with the knowledge that if something else, something changes when your children are a bit older, or I don't know, you win the lottery, for example, we all wish, but you could revisit it then and look at it at that point in time and come back to it. I think perhaps there is a misconception that it's difficult to do, or it's too hard to do. So quite often I'll have clients at the end of a consultation say, well, actually, that's been on my to-do list for so long, and I've just left it because I've been sweating over what I'm going to say, or not really wanting to think about it, and it's just gone to the bottom every time. But actually, that was a lot more painless than I thought it would be. Obviously, we do this day to day, so we will take you through the whys and the wherefores and the what ifs, and we do like to say, but what if this happens, what if that happens, and kind of try and future proof your will a little. I think there's that misconception that it is going to be difficult, whereas if you go the right way, maybe do speak to the right people, they can, one, make it easy, rest assured it's what they do every day. As Jill mentioned earlier, go to somebody who it's not a dabble, it is their specialism, and they will guide you through it. They'll ask you all the nuanced points, and you probably won't even realise that some of the information is being teased out of you. It'll be a bit of a conversation like we're having. And they'll get your background without you even probably realising. And they'll know the ins and outs of your family, what you want to happen, and they'll have covered, probably killing everybody off, going, oh, what if your husband's not here? What if the children weren't here? If they were grandkids, and going down the list. Yeah. But you probably won't even have realised that they've covered half as much as they have.
Yeah, there's so many points in there that I'm actually kind of remembering. But I think that, the point of, people going, I don't actually know I'm not sure what I want to do. So I'll wait and I'll think about it, and and then I'll come back to it later. But then time just passes, doesn't it? And you've still not sorted it. And it's not that you're waiting for a certain date. You just don't know what's going to happen in the future and what's around the corner. So I think it's almost better to go like, well, okay, well, let's make a decision about what's right for now.
Yeah.
You can review it, you can update it, and to your point, it's not that complicated as a process. So can we just talk about that process briefly? Like, what happens? Like, what do you do when you make a will?
So you should probably start by thinking before you sit down and speak to somebody, maybe about what you've got. What have you got to give? What maybe liabilities have you got? It might be mortgage, credit card debt, whatever. Who have you got to give it to? Who is there you might consider giving it to? For some people that might be quite straightforward. They might think, oh well, married couple, I just want to give it to my spouse, and if they're not here, then the children, for example. For others, it might be more complicated, where maybe they do have that complex family setup that we mentioned earlier, or maybe they don't have anybody obvious they want to give it to. But just having a bit of a think about your options. What have you got? Who have you got to give it? Who could you consider giving it to, and in what kind of shares are you looking at? And then speak to a professional, use a professional to do it. As they say, they'll guide you through everything you need to consider for the will. They'll think about the what ifs, as we mentioned, and then usually you'll get a draft to look at in the first place. Certainly at Hugh James you would do anyway. You can think about it then. Seeing it in black and white can sometimes get the kind of the cogs turning and other points come to mind, and that's fine. That's a draft for a reason, and then we'll tweak it, and only then, once you're happy with it, hopefully then that document you get reflects what you're after. And so then you'll sign it with two witnesses, independent people, and that's what makes it legally binding then. So it's that action.
To your point earlier, if you're like down the line, you've got more assets, or something's changed in terms of your family structure, or whatever, you can change it.
Yeah, absolutely. Yeah, you're not stuck with whatever you write today. We tend to suggest that people should keep the wills under review. Milestones, big milestones in life, marriage, births, deaths, the usual ones. But think about it with those. Maybe, as I said, the lottery win, the new job, the inheritance that you've got from parents that have passed away, for example. So changes in your financial circumstances. But then also, just check in with it every now and then in between as well. Has anything significantly changed? A lot of the time, things that have changed won't necessarily warrant you doing anything. Your kids might have grown up and moved out. You don't necessarily need a new will just for that. But that change in circumstance might have come along with something else. You might have given them one of them a gift to go off and buy a house with. So you might want to try and even that out by writing a new will to do that. But it's just a case of checking in with it every now and then. Can stay safe with us, or in a drawer if you at home if you really want. But you just just have a think about it every now and then. Yep, all good. No need, nothing to.
Yeah, and I think we evolve and we change as human beings throughout our lifetime, and obviously, as we say, our circumstance changes, everything changes, but our interests and our desires, probably as we get older, our sense of purpose and what we find meaningful, that all of that changes, and that can still also be reflected in your will. I can't say, like, we're very fortunate that we have a number of people who have told us that they put us in their will, as a charity. And I think it's being mindful that you don't just have to separate your assets or your finances amongst people around you. You can actually support your local community club, football club, a charity. There's many different ways that you can share that money.
And you could do that in a whole host of different ways as well. You get some clients who want to leave them a charity a set sum of money. Maybe it's one they've got a close association with, or a charity that they've had a family member be supported by in their lifetime. Sometimes clients want to give a portion, so a share in percentage terms of what they've got. Sometimes clients, as I say, have no one that they would want to leave it to, so choose to leave it all to charity as well. I've even had clients wanting to leave valuable items, say, to a charity, in the hope that can go and be auctioned off and make a nice sum for them. I've had another where it was specifically lifeboats in that occasion, but he wanted to buy a particular class of lifeboat for a particular station. So that was carefully worded in the will, but a sum of money went off to the RNLI, and his boat is
And that's a
now
legacy.
out on the sea.
That's a legacy to him. And I think going back to your point before, if you don't take proactive steps for this and something happens, you don't get that legacy.
No,
you don't get that
absolutely.
opportunity to say, I'm still going to make an impact, whether it's on your children or your spouse, or to a charity or to a community or whatever it is. You don't get that opportunity.
No.
So that's why those steps are so important. Before we just kind of like round off and finish down, I just wanted to talk to you about power of attorneys. What are power of attorneys?
So in short, they're documents that you sign allowing somebody else authority to deal with things on your behalf. So there are two different types. One is property and finances, and one is health and welfare. And in either of those, you're choosing the person who, if you can't make a decision, they will step into your shoes and do that for you. So if you think about a practical example of the property and finance one, I was power of attorney for my granddad a few years back. He was perfectly capable of making a decision for himself, but he did not like to telephone bank. He couldn't use a computer, and he was getting a bit immobile. And so if he needed somebody to sign a check for him, his secretary or attorney, Leanne, came and did it. If he wanted somebody to go to the bank and talk to them over the counter, then it was me. If they were trying to sell him something telephone banking related, again, it was me. But it was the power of attorney document that allowed me to do that and allowed the bank to recognise me as somebody able to deal with his finances for him. Obviously, he could tell me what he wanted to do because he had capacity, so everything I did was always with his consent. Whereas if he'd deteriorated and couldn't make those decisions for himself, then it would have just been me taking those on his behalf. So important that you trust, obviously, the people that you appoint, but very important documents. And to use the term I probably used about a will as well, insurance. It's there just in case. We hope clients don't need them, but once they're done, then hopefully that's there for those life-changing moments. Potentially, you used the example earlier of things that you get a diagnosis, and maybe it's a progressive illness, dementia, for example. You can plan for that. Whereas if you did have, say, brain hemorrhage and your capacity to make decisions was gone overnight, then a lasting power of attorney at least is there to allow your family or your trusted friends to do it for you.
And that's where it's helpful to be proactive. What if somebody's, let's say in this circumstance, has had a brain hemorrhage and they're severely disabled? So, they are disabled physically, but also, mentally as well. Can you, in that state, set up a power of attorney?
So it would need to be shown that you had capacity to understand what the document was. So if you didn't have capacity to take that decision and to understand the ramifications of signing that document, then it's still possible for somebody to be appointed in a role similar to an attorney, known as a deputy. But the process for that and process for getting it is far longer, far more expensive, and isn't immediate. So obviously, if you'd had the power of attorney in place, something happens, it's there ready to go, potentially, as soon as it's needed. Whereas with the deputyship route, you would need the time that it takes to go through the court process of choosing and appointing a deputy, and then obviously liaising with the banks, etc., which could take quite a while, quite a lot of money. And in the meantime, your family can't necessarily access your bank accounts, which, depending on your setup, if you're a married couple with joint names on a bank account, you might feel that that's fine and your spouse could get by. But if you're the sole breadwinner, so to speak, all the money is in your accounts and it can't be reached, then it could leave things, quite difficult for the family in that interim period.
Yeah. It's so funny when we talk about it here. It's the word that you used before is, I think, highly accurate: insurance. And I think if we can take that insurance out, it just helps in so many ways, from a practical point of view, from an emotional stress point of view as well. And we take out so many other insurances, for our phones and all sorts of things. And we're required to take out a number of different insurances for a number of different things. And I feel like if we should really be required to make sure that we are, once you buy a house, once you have a certain level of assets, whatever, that it is a necessity to have wills.
Yeah. And comparatively cheap compared to the alternative of not having as well. The alternative to the situation, for example, where you haven't made a will, then you have a brain hemorrhage or a serious accident, and you don't have capacity then to to take a step and make a will. The alternative is going down the route again of the courts and getting a will written on your behalf, known as a statutory will, which again takes time and money and a back and forth that might not necessarily reflect. You would hope it will reflect what your wishes were or would have been had you done it yourself. But there's a lot of, back and forth with family and interpretation about what might they have wanted if they could make a will. And obviously same can be said for the deputyship point as well. It's far more costly to go down that route than it is to take out the insurance to carry on with that analogy.
Yeah. That point about interpretation is really key, isn't it? Everyone then interprets, and everyone will interpret things in very different ways. Everyone has their own subjective opinion about what people want, what is right, etc., and it takes that out of it, doesn't it? And so when you think about what do I want with my own things, what impact do I want to create, that's really what a will is as well, isn't it? And so I think what this conversation has been really helpful from the will point of view and also the medical negligence point of view is actually recognizing the importance of being proactive with a lot of things, and actually how much that will help you, not just from a practical point of view, but an emotional point of view as well. And because it can be complicated. And as we said right at the beginning, brain hemorrhages are complicated, devastating, emotional enough. You don't want anything else which could add another layer of complexity too. So obviously, we will share links in our show notes directing, the listeners to, your pages on our website so they can find out more about, potentially setting up a will, or if they need medical negligence support as well. That's all there. That'll be in the show notes as well. But ladies, thank you so much for being with us today. Is there anything else you want to add before we close off? Anything helpful? Is there any advice you'd want to give anyone at this point?
No, just thank you for having us.
Yes, thank you very much.
Yeah, great. Well, thank you very much. Thank you for joining us for this really important conversation today on the legal and financial complexities that can follow a brain hemorrhage. And I hope that today's episode has helped you better understand what support you can get. A big thank you to our guests and sponsors from Hugh James for sharing their expertise. And if you'd like to learn more about how Hugh James can support you, whether it's with estate planning, probate, or medical negligence, you'll find the link to their services page on our website in the show notes to this episode. And if you found this episode helpful, please consider sharing it with someone who might benefit. And don't forget to subscribe so you never miss an episode. Remember that with all our guests in Series 2, we will ask them a special bonus question that you definitely don't want to miss. We asked Leanne today, what should you put in your will? And we also asked Jill, what is one question that is vital for people to ask themselves before starting a medical negligence case? To see the answer to these questions, simply visit our Instagram page and join our Change Collective broadcast channel, where we offer bonus content, the latest updates, and opportunities for you to get involved in promoting brain hemorrhage research and awareness. Next time, we'll be speaking to Katie Armstrong, who sadly lost her husband to a brain hemorrhage. In this immensely personal and emotional conversation, Katie will share more about what life looks like after loss and how she's picking herself up after this loss, not just for herself, for her children too. It is a conversation that I'm sure will resonate with so many people, and I'm so grateful to Katie for bravely coming on the podcast to speak about her loss. For now, thank you so much for listening today, and we will see you all in the next episode.